Welcome, everybody, to another episode of Big Data, Big Issues. I'm your host, Sheldon Kreger, and today we will be discussing FISA and Big Data. FISA is the Foreign Intelligence Surveillance Act, in case you're curious about the acronym. And we're going to discuss, first of all, the history of FISA, the kinds of authorities that it establishes for law enforcement when they're conducting investigations. And we're going to later provide some context around why big data technology is highly impacted by FISA standards and vice versa. In order to establish some context around why FISA is considered controversial, we need to think about how normal criminal investigations unfold in the United States and what kind of legal standards are in place. One of the key standards in legal cases, criminal investigations in the United States, is the concept of probable cause. Under the Fourth Amendment, a search warrant must be based on probable cause to believe that a crime has been or is going to be committed. So investigators or police officers or whoever, they need to have some kind of reason to be conducting an investigation on a person before they can get a search warrant in order to expand their investigation and begin gathering hard evidence to build a case against that person. And those kinds of things could be reports from people in the community. Someone sees a burglary, they report it to the police. Well, you're going to have probable cause in that situation. But what it doesn't include is continually monitoring everybody in the country and looking for evidence willy-nilly, kind of randomly or systematically, and really kind of cherry picking through data to see if a person is engaged in some kind of criminal behavior. And that's the kind of thing that in the United States we're legally protected against. There was some situations in the 60s and the 70s that led to a legal case. I'm not going to go into too much detail, but it led to a legal case that escalated to the Supreme Court. And what they started to realize was that although having these Fourth Amendment protections for American citizens seems to be ideologically agreeable in the courts and throughout the United States, the military and the intelligence community wanted to start having different standards for conducting foreign intelligence. So not being required to have probable cause in order to perform surveillance on foreign targets. And what the Supreme Court stated in 1972 is this: given these potential distinctions between Title III criminal surveillances and those involving the domestic security, Congress may wish to consider protective standards for the latter, which differ from those already prescribed for specified crimes in Title III. Different standards may be compatible with the Fourth Amendment if they are reasonable both in relation to the legitimate need of government for intelligence information and the protected rights of our citizens. And so this Supreme Court ruling opened the doors for Congress to pass FISA and create different standards for the collection of evidence in the context of foreign intelligence operations. In 1978, Congress passed the Foreign Intelligence Surveillance Act for the first time, and it established a separate legal regime for foreign intelligence surveillance. There were the FISA has to be reauthorized by Congress periodically, and there are ongoing, and historically there have been political battles fought around the kinds of authorities that are granted under FISA, and the different kinds of oversight within FISA to ensure that law enforcement are not overstepping their boundaries and that the intelligence community isn't overstepping their boundaries. And depending on the political climate at the time, the FISA looks a little bit different from time period to time period. But to give a brief history, at least recently, the important thing that happened was the attacks on September 11th, which led to the passing of the USA Patriot Act in 2001. And that contained some FISA amendments that expanded the authority to conduct foreign intelligence at a broader scale. And later, the Terrorist Surveillance Act of 2006 was also passed, and the Protect America Act of 2007. There were also more amendments to FISA in 2008. And in 2014, we had Presidential Policy Directive 28, or PPD 28. And even more recently still, there was the FISA Amendments Reauthorization Act of 2017. So that's just a brief overview of how much activity kind of takes place around this piece of legislation. And periodically they have to go through, and Congress needs to reauthorize. And in addition to that, the president has expanded the power of the intelligence community to do these kinds of operations. And it was the Supreme Court that really opened the door for all of this to unfold. So it's very interesting. Foreign intelligence gathering, for this reason, is fundamentally different than collecting evidence in the case of domestic crimes. Specifically, there is the ability to conduct broad surveillance on foreign targets without a warrant. And this is really the cornerstone. The crux issue is the need to have a warrant to conduct an investigation. And so when the United States performs signal intelligence overseas, they're able to gather information using a very broad net and then filter through that and look for things that they think are suspicious. And there's more recently, not only do we have traditional intelligence operations, you think of spies who are on the ground and they are monitoring foreign targets, and maybe they're working undercover to gain some insight into how an adversary is planning, how they're using their money, what kinds of military actions they're considering, that kind of thing. But more broadly, through cooperation and with telecommunications companies and technological development in the internet, the intelligence community has really expanded its scope of investigations to include forensic evidence collected over the internet. And this allows preventative operations. It also allows predictive operations. And it's an area of controversy. However, one of the key aspects of reining in this kind of investigation is that there's a requirement called minimization. And the risk is that when an investigation is ongoing on a foreign target, out of necessity, there's also going to be information collected about domestic targets. So you're going to end up gathering information about American citizens without a warrant. Because, for example, if you're listening in on phone calls for conversations for a suspected terrorist in Iraq, and they're calling over the phone to groups in the United States or people in the United States, you're going to be spying on the people in the United States who are on the other end of the line, even if you were only inspired initially to look at the phone records or listening on the phone calls of the person in Iraq. The way the law works is if there's an investigation on a foreign person and they contact a citizen of the United States, that person in the United States is now a legitimate target of investigation, and warrants can be issued against that individual to continue further investigation. And so one of the big hot topics in FISA is the concept of minimization, to ensure that this is only being done under certain circumstances and when it's absolutely necessary. And so minimization refers to requirements and procedures that have been implemented to minimize the collection, retention, and dissemination of information about United States persons. And they're really designed to prevent a broad power of foreign intelligence gathering being applied in routine criminal investigations in the United States. There are requirements before a FISA warrant is issued against a foreign target, or before a surveillance program is chartered and kind of put underway. There has to be a specific target. That person must be a foreign citizen, and there has to be evidence that this information that we're trying to gain is of real value. And you can't just target a person for criminal activity alone. There are some other requirements. That there has to be, for example, the threat of terrorism or some other kind of attack on the United States, or it has to be a really important for the interest of the United States to have this kind of information. And that being said, any evidence that's gathered in this process, the evidence can be used in criminal investigations and for criminal charges. So, for example, if a FISA warrant was issued against a person, say in Afghanistan, who is a suspected terrorist, and then instead of finding out that they're a terrorist, they found out that they were involved with credit card fraud or something like that, they could use that information to press criminal charges against those individuals. Kind of a strange example, but I think you understand the picture. And another aspect of requirements for these FISA investigations is a requirement for probable cause. Surveillance under FISA is permitted on a finding of probable cause that the surveillance target is a foreign power or an agent of a foreign power, irrespective of whether the target is suspected of engaging in criminal activity. There are further requirements for FISA. There has to be a description of the nature of the information being sought and the type of communication or the activities that are to be subject to surveillance. And of course, there has to be specific detailed information about how minimization procedures are going to be handled. And there also has to be a time limit for how long this kind of intelligence will be gathered for. Now, one of the things to keep in mind is all of this happens in a secret courtroom. So the actual legislation, FISA, established a FISA Court, and the ongoings of the FISA Court are held in secret, and they're not open to public scrutiny because, by definition, these are operations that are of national intelligence value and are highly secretive. And if a lot of these investigations were released, it would provide a strategic advantage to foreign enemies of the United States. So there's a issue of transparency. There's a lot of controversy around the lack of transparency surrounding the FISA court system, the FISA warrant, the way FISA warrants are granted, as well as how the minimization procedures are actually followed. There's just not a lot of information available to the public, or really anybody for that matter, giving details about what kind of compliance is actually going on behind the scenes. And this is kind of what's raised a ruckus in the news recently. And this is what's inspired me to take some time to discuss this topic. Is historically, this has been a somewhat bipartisan issue, reauthorizing the FISA Act. Typically, Democrats prefer to rein in the intelligence community and limit the scope of the kinds of investigations they do, and impose greater minimization requirements and create some kind of requirements for transparency and so on. And then the more hawkish right-wingers, conservatives, Republicans in the United States are typically more focused on national security and want to grant more authority to this court system and give the intelligence community more tools and more capabilities to perform more foreign intelligence and to do so more effectively. And what happened recently is the conservatives, many conservatives in the United States have grown to really just absolutely hate the FBI, to be honest. And this was a consequence of the Robert Mueller investigation into President Donald Trump for some alleged coordination with Russia for an election interference back in 2016. Historically, I'm sure everyone listening to this podcast recently is going to be very familiar with that situation. Just for historical purposes, I will say that there have been recently in the news a lot of conservatives coming out, speaking out against FISA and using a lot of the talking points that Democrats were using back in the early 2000s when the Patriot Act was being implemented and so on, that the FISA court system is broken. There's not enough transparency. The warrants are being issued too liberally, too often, and with too broad of a scope. And they point to this situation with Donald Trump as an example of the FISA courts overstepping their boundaries in the intelligence community, not really using valid evidence in order to begin investigations in the first place. And this is really a key point to bring up, which is when a warrant is requested from the FISA court, the decision to open an investigation is absolutely critical in both criminal proceedings in the United States, but also in foreign intelligence. Because if the court rejects the very idea of beginning an investigation on a person or on a foreign nation or whatever it happens to be in context of whatever court system we're talking about, if that is rejected by the judge, then the case goes nowhere, and the ball never starts rolling. And basically the law enforcement either have to just give up or move on to something else, or they have to continue looking for some other kind of piece of evidence to go back and reapply for a warrant later. And so this is really a crucial point in the criminal process or in the intelligence process, is the initialization of a warrant and the initialization of an investigation. Once an investigation is unfolding, any kind of records, any kind of evidence that's gathered in that process can be used to further establish even more investigations later, including unrelated crimes. So to step away from foreign intelligence for a moment and just think about courts in the United States. If a person is put under investigation for selling drugs, for example, and the police have some kind of evidence, they got reports from neighbors or something that there's some suspicious activity at somebody's house or whatever, and they get a warrant to kind of monitor that household and gather some personal information, maybe phone records or whatever about what that person's been doing. If they dig up some other dirt in that process that's totally unrelated to drugs, for example, credit card fraud. I don't know why I keep coming back to that, but for example, they discover this person's involved with credit card fraud, then they can actually pursue charges on that. And that's also how it works in the context of foreign intelligence. So that's really the primary criticism coming from both the right and the left now, is that the evidence that's being used to initialize investigations is just inadequate, and it's causing an overstepping of authority by the FBI. And this is really a very interesting development because it's been a very bipartisan issue, but more recently, because of the investigation of Donald J. Trump, there's been some consensus on kind of reining in this process. However, there are many other shortcomings to the FISA process that I think you ought to be aware of. As I mentioned earlier, the records are sealed. Once the Foreign Intelligence Surveillance Court is what it's called, once they basically anything that they do, there's no access to any records granted, even if you're defending yourself from an investigation. So if you're under investigation and you end up in court with criminal charges, you will actually never find out how that investigation was started and how probable cause was kind of established for the warrant in the first place, as well as any other proceedings in the courtroom or related to the process at all. So that's really a unique thing in context of the Foreign Intelligence Surveillance Court, I believe. The FISC, or the Foreign Intelligence Surveillance Court, it has a court of review where if somebody objects to some step of the process internally and someone speaks up and says, this was unjust, something that happened, there's a court of review to look over cases and provide some kind of check and balance internally. But the problem is that historically, there's only been one appeal that's ever been brought up to the FISA Court of Review. So this exists, but it doesn't get used. In regard to accountability within the system, there's actually no provision for certification that the surveillance is conducted according to the warrant and that the minimization requirements are being met, or anything like that. So there's really no outside watchdog that makes sure that they're following their own rules. There's been, on top of all this, there's been a degradation of standards over time. As originally passed, any FISA investigation must have had the collection of foreign intelligence information as its sole or primary purpose. However, the USA Patriot Act expanded the application of FISA to those situations where foreign intelligence gathering is merely a significant purpose of the investigation. Significant is not defined, and the vagueness leads to inconsistent determinations of what ought to be investigated and what ought not to be investigated, and has led to potentially overuse of this kind of intelligence and investigations. So, to start to step back to how this matters in the context of big data, as you can imagine, with the rise of big data technologies, the amount of intelligence that's out there for foreign intelligence that the intelligence community can use to conduct surveillance and perform investigations has dramatically expanded. And corporations in the United States have a lot of information about individuals, an unprecedented amount of very detailed information about individual activity. And this, of course, can be very valuable to investigators when they're conducting an operation. And so there has been cooperation between investigators and corporations in the United States under court orders or warrants issued by the FISA Court. And this was something that was going on that nobody actually knew about originally. So long story short, and this is not something that I'm going to be diving into today, but in 2013, there was a release of classified documents by a systems administrator working as a Department of Defense contractor, whose name was Edward Snowden. And he put out all this information about how widespread these kinds of operations actually were. And the picture that was painted at that point in time was that, and whether this is accurate or not, that's up to you to determine, but the picture that was being painted by the media and certainly by Snowden was that there was an overstepping of authority by the intelligence community in this cooperation with big corporations. And we'll get back to that in a moment, but it's a very interesting problem because when companies are faced with a warrant and they're told that they have to hand over records about a specific individual or a group of individuals or whatever, they actually have to comply with that by the law. And furthermore, they can't actually notify the person who's under investigation. And not only can they not notify that person, they can't tell anybody at all. So when an investigation is being conducted, there's some kind of coordination between the intelligence community and corporate America. That's all done completely in secret. And if the corporations were to let that information out, it would be very bad news for them. And so this has led to a lack of transparency that ultimately led up to the release of the documents by Edward Snowden, kind of as a form of protest. And what Snowden really the picture that was pointed at that point in time was there were a variety of programs where there was mass collection of information going on, specifically metadata about phone calls between Americans and people overseas. And so certain telecommunications companies were were being pressured and required to hand over huge amounts of data about every single phone call that was going on between an American citizens and foreign intelligence assets, was kind of how it was painted. And there was this widespread just handing over of all this data to the FBI and the CIA and whoever else, the NSA. And then that data was being used for intelligence purposes. And, the argument from this side of the ideology is that that would be an overstepping of the boundaries from a constitutional perspective. It's really an infringement upon individual privacy. If you have the time, I'm going to be recommending some books at the end that actually discuss not just Snowden's perspective, which is very, very much worth a read, but also the perspective from James Clapper and Michael Hayden, who were really running the intelligence organizations, Director of National Intelligence, CIA, FBI, NSA. They were directing these programs when all of this was going on and when all these programs were being built out and expanded. And in their books, they really provide quite a substantial defense of these operations. And what they say is that the only records that were being requested and the only records that they ever wanted to have were ones that were for specific targets. Remember, if we go back to some of the requirements for a FISA warrant, the investigator has to have a particular target that they're trying to gather intelligence on. And so while Edward Snowden and the liberal media had portrayed this mass gathering of every phone record of every American citizen, what was really going on, at least according to the intelligence community, is that they were actually surgically going in and saying, we have this foreign, we have this potential terrorist who's contacting Americans, and we're just gathering some information about that person only, and that's all we've been getting. However, this was largely disputed by the evidence that Edward Snowden presented, which I do not have time to review at the moment. But this, to me, stepping away from my normal neutral perspective on this, to me, it's really, the problem is the lack of transparency, because what happened was whatever was going on at that point in time, nobody knew about it. And, nobody outside of the intelligence community really knew about any of this stuff. And, under penalty of law, they couldn't talk about it. And so the system probably had some internal problems. And that's certainly what Republicans today are saying. But this kind of led to a person an individual who felt like they had a moral obligation to speak out against it and was able to gather all this evidence as a systems administrator and let all this stuff out in the open, and then totally defeating the whole purpose of trying to have secrecy around these programs in the first place. And so really it kind of the idea of keeping all this stuff secret has really backfired for the intelligence community. And while I believe there are valid reasons to have secrecy in a lot of situations, I don't know that the precedent of keeping all of this kind of thing secret indefinitely is going to pay out or is even really sustainable in the long run. I'm very skeptical about that. That being said, I do believe that there are plenty of situations that require secrecy in order to avoid providing some kind of information to foreign enemies of the United States. So it's a very delicate balance, and it looks to me when I did a review of how this FISA system works, and when I listened to conservatives on the radio on YouTube, and certainly when I was younger and I was listening to the media, when the Patriot Act was being passed, and when there were different all these reauthorizations, this stuff comes up over and over again on the news cycle. And it just seems that it's kind of a broken system. And I think that that's pretty much admitted by both James Clapper and Michael Hayden in their books as well, that it needs a lot of work. And this is kind of what the Congress is responsible for. So that really summarizes the conversation, a very brief conversation about how FISA works, the Foreign Intelligence Surveillance Act, with the kind of authorities that are established, the FISA Surveillance Court, Foreign Intelligence Surveillance Court, and the kind of coordination, what we know at least about the coordination between corporations in the United States and the intelligence community. And of course, the argument is that when there's not transparency about what's happening in these operations or what kinds of legal precedents are even being followed, Americans are rightfully suspicious that there's some overstepping of authority going on, and maybe there's more broad, data being collected and analyzed about American citizens or about foreign citizens or whoever. So this is all very controversial and all very interesting to me. If you'd like to learn more, what I would recommend, first of all, is looking at just Wikipedia about FISA and EPIC. I can't remember what the organization's name is off the top of my head, but most of the information that I shared here, I pulled straight from the EPIC website. They're a privacy advocacy organization. And you can find more detailed information about the internals of the Foreign Intelligence Surveillance Court and stuff there. But I would also encourage you to pick up a couple books from the intelligence community and the leaders of the intelligence community, because they present a very compelling case for continuing this kind of work and providing examples of where American lives were saved, or there were strategic advantages that were gained by using these programs, terrorist operations that were being thwarted. And they talk about a lot of the legitimate uses of this technology and how important it is. And I think that gets lost in the conversation a lot of times. So specifically Michael Hayden's book, The Assault on Intelligence, American National Security in the Age of Lies. This book is a memoir. It's basically an autobiography from Michael Hayden, who was the director of the NSA, the director of the CIA, and also the director of national intelligence throughout the Obama era, maybe under Bush as well. Can't remember. But yeah, find some podcasts with Michael Hayden being interviewed at the very least. If not, pick up the book. I personally listen to an Audible, and I have a hard copy so I can reference it for this podcast. Extremely interesting career that Michael Hayden led, and provides just like a very intelligent conversation about these topics. Well worth the time. The second book I'd recommend is called Facts and Fears, Hard Truths from a Life in Intelligence by James Clapper. And similarly, James Clapper was the director of national intelligence for a period of time under Barack Obama and worked in signals intelligence as a career. Highly respectable individual and very much concerned with the well-being of American citizens and the safety of the country and, the United States as a political power internationally and so on. The book is, again, it's an autobiography, memoir, and you can really learn a lot about his perspective on why these kinds of operations are important and what kinds of changes maybe ought to take place within the legal system, and the kinds of problems that they run into day by day on the intelligence community. It's a really fascinating read. And then, of course, there's no way that you can look at this topic at all without hearing about Edward Snowden. And he recently released a book called The Permanent Record. And this is, an autobiography where he describes his childhood and stuff, which is pretty boring. I'm not going to go through the whole book, but he spends the majority of the book discussing his career working as a contractor within the intelligence community and how he gathered up all these records and how he decided to release them and what happened when he released them and all this kind of stuff. And it really also portrays his political ideology very clearly, which I thought was really interesting, and explaining how he kind of arrived at the conclusion that he was morally obligated to reveal these programs and present really firm, solid evidence to show that this kind of thing was going on and that there were these alleged abuses of power that he perceived. So definitely worth reading and seeing both sides of the issue. And with that, I'm going to wrap things up. Thanks so much for joining me today. And I hope that you have a productive day and that you are able to dive in and learn more yourself. The best way to support this podcast is to like and leave comments, as well as share the episode with your friends and colleagues. You can find detailed notes, reading suggestions, and a complete episode list at bigdatabigissues.com.